Hi, I'm Jonas Urba. I'm a New York employment lawyer here with Employment Law Reality Check. Social media policies. Most employers have those today. You should read your employer's social media policy carefully. Make sure you have a copy because I get quite a number of calls from people who've posted something on social media somewhere and they think that they've limited the number of people who are going to have access to that social media, and that doesn't mean that they did not violate confidential information or potentially even a trade secret of their employer. And so you have to be very, very careful about posting anything on social media today. And it really doesn't matter if you limit it to friends or if you limit it to just a few people, because I've even had members of families who have actually forwarded social media posts to employers when those employees felt that they were confidential and that their employer would never have a way of discovering what was posted in potentially a private or limited social media post. So what I suggest every employee do is very, very carefully read your social media policy and follow it to a T. Here's a couple of examples of where you can really go wrong. Number one, you do a video or a recording of some type on your employer's premises. That generally is not a good idea. That's just about as bad as wearing a company uniform or your name badge or something else that identifies your employer, and then you discuss things possibly not in the best light of the employer. For example, you express your opinion about your workplace and it might not be the most positive opinion. Remember, you have a duty of loyalty to your employer. They pay your paycheck, therefore you have to actually keep their interests paramount. That's the common law duty of loyalty. But getting back to social media, if you're going to share things that are negative comments or any type of things that the company may not agree with, or your thoughts on that opinion, whether it's political, religious, whatever the opinion is, if it doesn't mesh with your employers and you post it out there somewhere on social media, on the internet, regardless of whether you think that it's limited to a number of people, don't do it. Because that itself could violate your social media policy of your company, and if you violate policy or you breach your duty of loyalty to your employer, remember, most employees are at-will employees, and there's no reason is a good reason to terminate an at-will employee. So before you do that, read your social media policies very carefully and make sure that you keep a copy of anything that you sign. Employers nowadays are having everybody sign either employee handbooks or COVID-19 policies, sexual harassment policies, social media policies. Make sure you keep those documents because you never know when you're going to have to take a look at them and see if you can post something or if you can express an opinion which you think might be confidential, or you might be posting it anonymously, and all of a sudden your employer figures out who it was that posted that, and it put the employer in a bad light, and all of a sudden you find yourself looking for a new job. So before you do that, call some employment lawyers. If you have any questions, I get quite a number of people that call me and they ask me to review policies. They ask me to review the procedures, employee handbooks. Sometimes they're even on a PIP already, and I'll work with those employees and try to keep their jobs. And if that's not possible, then we're talking about any other avenues of recovery in a worst case scenario if you do lose your job. Call some employment lawyers. Call me. I'm Jonas Urba. I serve the entire state of New York, and I can be reached at